Hi friends, let's continue with section 19 where we left last time, and I was emphasizing the importance of the 5 illustrations in the section which are provided as a part of the statute. In this case, there is a case decided by Allahabad High Court. It is called Havaldar Singh versus Aditya Singh, in which a document intended to be in favor of A was, as a result of fraud played by the defendant, was conveyed to B. Now, obviously, this transaction would be voidable under Section 19 because there is element of fraud. Rescission is available under this section if the consent is caused by fraud and the right to rescind in case of undue influence is dealt in Section 19A. We shall deal with it presently in a little while. Now, repudiation, it must be noted, must not be in parts. If it has to be repudiated, it has to be complete altogether. Friends, while dealing with this, we have to understand that when a voidable contract is avoided, it does not mean that the contract never existed. It only means that it ceased to exist from the moment of avoidance. Now, friends, please remember there is a typo here where the ceased is written wrongly. Actually, it should be CEASCT. And the moment instead of it should be moment. It's a typo. I apologize for that. In East India Commercial Company versus Collector of Customs, case decided by Supreme Court in 1962, it was held that a license obtained by fraud was only voidable, and hence it was good till avoided and in the manner prescribed by law. So the Honorable Supreme Court has said that the license will continue to be valid until it is voided. This is a very important case to be kept in mind. And it was particularly a lesson learning case where collector of custom tried to defend the case. However, this judgment accepts the principle that misrepresentation does not make a contract non-est, which is non-dependable, but is only voidable. The right of a party defrauded is not affected by mere lapse so long as he remains ignorant of the fraud. Friends, let me repeat this. Right, if you have been defrauded, your right will not be affected by the mere lapse, but on the condition that you have to be ignorant of the fraud. This is an important case which was decided by King's Bench in 1917 and is reported as AIR 1917 to King's Bench 822. What about third parties, friends? Friends, since a voidable contract is valid until rescinded, during the interregnum, third parties acquire rights bona fide without notice and for value. Now, just let us try to understand and digest this. In the previous case decided by the Supreme Court, we said voidable contract is valid until rescinded. So also, this was decided by the King's Bench in Armstrong case. So therefore, what happens during the interregnum? During the interregnum, the third parties who happen to deal with us, they acquire bona fide rights. If they did not have notice of the rescinding or the voiding, and for value, there has to be consideration. Or even if the position of the wrongdoer is affected, the contract cannot be rescinded. That's the force of the contract in regard to rescission, where third parties come in. Even if the position of the wrongdoer is affected, it will be the rights of the third parties remain protected. The contract cannot be rescinded. Sitaram Raju versus Bayana is a case decided by Madras High Court in 1894. This is a very important case in the matter of protection of the third parties who, for value, acquired the rights bona fide. Bona fide means without notice, that they were not a party to the fraud or undue influence. Now come to the restitution in the integrum. A party exercises his option to rescind, a party which exercises his option to rescind, they have a right to be restored, is entitled to be restored as far as possible to his former position. If a party which has the option to rescind, they are also entitled to be restored to the former position. For example, let us say that I was a person who was willing to sell my house to A, but due to the fraud played by a defendant, the document was shifted, the name was shifted to B. Now I have a right to avoid this, rescind this contract, and I have a right to be also restored to my original position, that is, remain as the owner of the house. Satguru Prasad versus Har Narayan Das, a case decided by Privy Council in 1932, has laid down this proposal, and the citation is AIR 1932, Privy Council 89. Friends, Section 19A was inserted by the Amendment Act 1899, and it was to give, with a view to give express sanction to the Indian courts in the case of unconscionable money lending of relieving borrowers against the oppressive terms of his contract. Because you might have seen, mostly in movies or in the history, that we had blood-sucking lenders in the villages to the farmers and to the poor. So in this purpose of this section, insertion was 1899 to help the poor borrowers and to relieve them of the oppressive terms. Now, in case of undue influence, the contract is voidable at the option of the party whose consent is so caused, and such a right, once exercised, is exhausted. Friends, again a typo. The ones that is written here is actually ONCE, not ONES. ONCE, not ONES. Friends, let us understand the ratio of the case decided by Calcutta High Court in Kunjalal Bhuiya versus Haralal Bhuiya. The case is decided in the year 1943 by Calcutta High Court. And it says there is no locus pendentium in either case. There is no residual locus. Once a right to rescind or declare the contract or to exercise the contract as void then it is exhausted. You cannot go on exercising it. Today you would void the contract, then you say, I restore it. No, that's not possible. Friends, Section 30 of the Specific Relief Act 63 clearly provides for an order of payment of compensation by the person in whose favor rescission is granted. And that is in addition to restoring the benefits received. So, Specific Relief Act comes to the rescue. Section 30 provides for the order of payment of compensation in addition to the restoring the benefits received. In fact, sections 27 to 30 of the Specific Relief Act makes similar provisions. Friends, O'Sullivan versus Management Agency and Music Limited is a case where a contract with a young, inexperienced singer was set aside on the ground of undue influence. Court held that the singer who had gained fame and earned money was asked to render accounts for the profit, but singer was also entitled to reasonable remuneration at work. Now, this was getting too far, where you groom a young singer and then you ask him or her to render accounts of what she has gained or what he has gained, and that's like exploitation. So the Honorable Court decided that the singer was entitled to retain and keep the reasonable remuneration for work. Friends, let's move on to section 20, which says agreements void where both parties are under mistake as to fact. Now, that the mistake was bilateral as to the fact is essential. One party's mistake does not make the contract void. One party mistakes certain thing in regard to the fact. No, it has to be bilateral. Erroneous opinion as to the value of the subject matter is not in the state. For example, I might think that uh, that the particular painting I had would be worth 20 lakhs and end up selling this for 2 lakhs. Now, that's not something that is mistake as to the fact. Fact has to be with regard to whether it is the same painting which I was intending to buy and the other person was intending to sell, has to be the same. It has to be bilateral mistake. Now, the mistake described in this section is regarding some state of facts which did not exist at the date of the agreement. Such a mistake invalidates the contract. Friends, Honorable uh, author G.H. Trettel said, the rule of mistake as invalidating the contract is confined within the narrow limits, only within the very, very narrow limits, where the extreme injustice of holding one party to the contract outweighs the general principle that the apparent contract should be enforced. Friends, what we need to understand is number one, is it the same object where the parties, it has to be in regard to factual mistake, it has to be bilateral, and that's the purpose of this section. Friends, in the type here, I will quickly mention a case called Bell versus Lever Brothers Limited, appeal cases, 1932. It was held if mistake operates at all, it operates so as to negative, in same case to nullify consent. For example, if it operates at all, it operates to negative in the same case to nullify the consent. For example, types of mistakes. What are they? It could be unilateral mistake, it could be bilateral mistake, it could be mutual mistakes. Parties are not consensus at item. I am saying something, the other party understands something. So that rule of the same thing in the same sense is here mistaken. Common mistake, parties are ad item, but subject matter has actually perished. Like I have said that I want to buy a particular horse which the vendor had, and that horse had died. So, since the horse had died, obviously there is a common mistake, and that's the spirit of Section 20. Now, the doctrine of mutual mistake cannot be invoked by a party who has no reasonable grounds for his belief. Friends, this is a very important case decided in the case citation is Associated Japanese Bank versus Grande do Nova, 88, 3 All England Reporter, 1902. It has said the doctrine of mutual mistake cannot be invoked by a party who does not have any grounds for his belief. And belief could be about anything. So therefore, if he has to invoke the doctrine of mutual mistake, he has to have a reasonable ground in his support. Friends, let's move to section 21. This section stipulates that a mistake of law in force in India does not make a contract voidable. In the previous section, we were talking about mistake of fact. Here we are talking about mistake of law. But a mistake of foreign law is to be considered as a mistake of fact. We'll give a small illustration. A and B make a contract on the erroneous belief that a particular debt is barred by Indian law of limitation. This contract is not voidable because there is an erroneous belief as to the law of limitation and whether there is limitation will operate against this or not. A contract, that's a different, it's an erroneous belief. However, if A and B enter into a contract grounded in the belief regarding the law regulating bills of exchange in France, then the contract is voidable. Because here, if it is an erroneous belief, then, friends, this section makes that contract. That's the distinction between the Indian law and the foreign law. Friends, mistake as to the general law is no ground at all for relief. And this is further reinforced by the unidroit principle, which make a mistake of fact as a mistake of law, Article 34. The Privy Council, in the case of Seth Gokul Gopal Das versus Murli and Zalim, 1875, 51, A appeal cases, 78, has laid this, has given a very clear explanation, and the dictum is this was no doubt a mistake of law on the part of, friends, here again a typo, please. Past is printed here. Actually, it is the part. There was no doubt a mistake of law on the part of defendants in supposing that execution could be issued for interest upon the amount decreed from the date of decree to the date of realization, no such interest having been awarded by the decree. But the mistake appears to have been common not only to the plaintiff and defendant, but also to the court which made the order of attachment. So this is the dictum of Privy Council, where they say there was no doubt a mistake of law on the part of defendants. In regard to what? In supposing that execution could be issued for interest upon the amount decreed from the date of decree to the date of realization, whereas no such interest was awarded by the decreeing court. The mistake appears to have been common not only to the plaintiff and defendant, but also to the court, which made the order of attachment. Friends, we will continue further. Thank you very much.